So, for viewers that aren't familiar with arbitration, I think maybe break it down from the 58 Convention forward, because it's a crazy thing the first time you hear about it.
Sure. So the New York Convention created this framework whereby parties are entitled to contract out of their national court system for the resolution of disputes over their contractual relations. So where the two parties agree, typically at the time they make the agreement, they agree to engage in trade with one another, but potentially at a later stage where they opt in, they agree if some dispute should arise over this contract, we will not resolve it by recourse to a court in any jurisdiction. Instead, there will be a defined mechanism for appointing a private judge, an arbitrator who will decide the matter between us. And the attraction of this is you can know in advance that any dispute that arises out of your contract is going to be resolved by someone who you have a role in appointing, or at least you've specified the mechanism for identifying that individual, according to rules which you've agreed in advance, and in a language that you understand, in a location that is accessible to you. And the beauty of the New York Convention is that once you have that decision, once the arbitrator has decided that, whatever was in dispute, you can then take that arbitration award, that decision, to a national court to enforce it. And there's no getting around that final step,
yes.
Although the blockchain will open some interesting opportunities for an arbitrator with the authority directly to manipulate the blockchain, potentially to both give the award and immediately enforce it, simply by changing the state of what is effectively the register of where the rights lie in these assets.
So, for example, releasing an escrow automatically, making a payment, or reverting ownership of property on the chain register.
Exactly.
Kind of stuff. Yeah.
So there will be a class of disputes which are now much more efficiently resolved. But even where there's some physical asset out there in a particular jurisdiction that that somebody needs to get their hands on, and they have the piece of paper from the arbitrator saying this is yours, they are going to have to go to the national court. But this is about as minimal as you can make the national court's involvement, and fortunately it's about as simple as any kind of court action gets, to take an award, an arbitration award, to a court and say, okay, just give me the writ that allows me to seize this asset.
Yeah.
So you're minimizing that risk in the jurisdictional risk. There may be complications of language, you may not fully trust the integrity of the system, but you've absolutely minimized your reliance on the national court.